Hi, everyone, and welcome to another week of conflict resolution and labor negotiations. So, we are at week 6. We are kind of turning the corner, headed not quite at the home stretch yet, but we are certainly making the turn for that last lap into the finish line. Okay, I hope you're enjoying the course so far. I know that some parts of it can be a little dense and maybe legal heavy, right? Law heavy, litigation type reading that is not the friendliest of readings, right? And the most enjoyable, but certainly there are some things that we can take, some lessons that we can take and apply in our daily lives, in how we approach conflict in our jobs, and what can we learn from these different strategies, these different ways of handling and dealing with conflict, how we can apply that to our lives and our jobs. So let's get started on this week's material. So we have a few things on deck for this week, right? We are in the baseball season is underway, and for those of you that are baseball fans, and California is a big baseball state, so I hope you're enjoying the season. It's really nice to see the fans back, at least in part. My team is not doing so well, so that's not as good as I expected, but hope it gets better. So for this week, we have the deliverables, right? So for this week, we have the readings, the Eisenhart and Spangel. This is the Black Book. It's easier to remember it as the Black Book. So we have chapter 7 of the Black Book of this Eisenhart and Spangel, and then we have chapter 2 of the Najida and Stern textbook for this week. You also have a few videos which are interesting. They're not that long, but they're actually quite intuitive. So I encourage you to watch them. You have a early neutral evaluation video, which is very quick, 2-minute video. Then you have the E&E process, 15-minute video. This is an interesting video. I'm sorry. Then you have one video that is a dispute review board video. Then you have a mini trial video, and then you have a summary jury trial video. And these are the different strategies, or the different or the hybrid alternatives to negotiation that we cover in this chapter 7 of the I always forget the name, Eisenhart and Spangel. So they're quite good, and I think they certainly do a better job than I would do in trying to lecture based on what they say, right? The videos are much better. So I encourage you to watch the videos, and you're going to get a simple and nice understanding of the concepts discussed for this week. And then we have the as far as deliverables, right? For deliverables for this week, we have the multimedia discussion board, I believe. Yes, the week 6 discussion board. And we have the also the week 6 assignment. This is the thesis style essay, right? So we have that, and we'll talk about those in more detail here in a minute. But before we do, let me just kind of quickly provide a brief kind of introduction of what the topic of this week's lecture is. Okay, and as we said, this week's topic, and especially the Black Book, the Eisenhart and Spangel book. This one addresses these alternatives that allow us to address conflict, right? For example, we have the book talks about fact finding, early neutral evaluation, which is the ENE, and there's a video on that, the dispute review board, a mini trial, and a summary jury trial. Okay, and very, very briefly, what are these? Well, fact finding is just what it says, right? It's if we find ourselves in the middle of a problem, of a conflict that we need to resolve, one way to resolve it is by looking at facts. So going and finding facts about both parties, and then based on the facts that we find, that will allow both parties to perhaps find some common ground and understand each other better, and maybe find a solution without having to go, say, to trial, right? So that's fact finding. Then the early neutral evaluation would be best used for cases that involve like an injury at work or discrimination cases, where the court will appoint a neutral third party, usually a lawyer, and this third party will hear the facts and the arguments of the case, and then will provide an early evaluation. That's why it's called early neutral evaluation. We'll provide an early neutral evaluation of the facts, right? Like a legal opinion. And what this allows is it allows the parties to make a decision about whether they feel it is in their best interest to go to trial, or if it's in their best interest to stay away out of trial, out of the court, and try to find a solution outside of the legal system, right? Because what is found in the early neutral evaluation is not legally binding, so it gives you a lot more flexibility, right? And then you have a dispute review board. Is usually something that you would use, or a strategy that you would find appropriate for big projects like infrastructural projects, where you have a lot of moving parts, a lot of potential opportunities for litigation, suits, and that kind of stuff. And so the board provides an opportunity to manage the conflict, manage communication between these large parties, and do it in a manner that is managed, that really mitigates the risk. It allows both parties to understand the process, to see if there's improvements in the situation that would reduce the tension or the issues. Maybe there was an issue at the beginning of a project or a process, but with time you find that the issue is being remedied. And so the dispute review board gives you that flexibility to manage communication among parties. And then you have something called a mini trial, which is what it says. It allows those involved, right? The parties involved in the litigation to engage in a hearing, okay? A hearing that is not a legal hearing per se, but it is formal, and it allows these individuals to resolve a dispute, okay? For example, this is common in cases involving contracts or product liability, grievances by employees, things like that, okay? So that's what the mini trial alternative is for, and it's usually found for these types of trials, okay? And then last but not least, it's the summary jury trial, okay? And the summary jury trial involves, again, a non-binding trial, okay? And the idea here is parties can sort of stipulate that the what happens in the trial is that you essentially have you're allowed, the parties that are in this summary jury trial are allowed an opening statement, and they're allowed to present their case, and then they all the questions asked are addressed. All of this is handled obviously by lawyers, right? And the jury will then deliberate on the facts of the case and arrive at a verdict, okay? And if both parties agree to the decision, then or the settlement, because in many cases this is what happens, then that'll be the end of that. But if it's not resolved, if those things don't get resolved, then usually you end up having to go to court as a last resort. Okay, so fact-finding, early neutral evaluation, dispute review board, mini trial, and summary jury trial are these alternatives to addressing conflict. Okay, now what is characteristic of these hybrids, right? These hybrid methods, these alternatives. Well, parties lose a little bit of control over processes and outcomes once you engage in these different alternatives. Okay, parties will lose control over the end result. If you do go to these more formal hybrid type of systems, right, or hybrid type of remedies, the shift is to who is right and who is wrong, and not so much in finding a solution, but you rather enter into a battle as to, okay, I'm right and you're wrong type of thing, and you're really trying to find a win-loss situation and not a win-win situation. They are less private because there's a lot of information that would otherwise remain private that becomes public, and of course with litigation everything becomes much more formal. Okay, so it's something really that those that enter into these agreements and that are litigating, that are trying to find solutions to their problems, do have to take into consideration before going into a formal litigation process. Okay, so for this week we have, as I said, we have a few deliverables. So let's talk very briefly about those deliverables. You have, the first one is the multimedia discussion board, and for this one, let's see, you are to locate 4 journal articles, and one each on the following ADR. So one on each of these that we talked about: early neutral evaluation, dispute resolution board, mini trial, and summary jury trial. Then locate a minimum of one news story on one of the ADRs above, okay? And then you present the following for each journal article. What did the textbook say about the topic? What did the article say about the topic? What was similar? What was different? And then you summarize the news that you located, and then remember to, what did you find most interesting about the news story, okay? So limit, please, limit your, I forgot here too, limit your presentation to 5 minutes, okay? Remember that slides should be graphic heavy, and also don't forget to respond to, in this case, to your other colleague, right? To respond to at least 2 other colleagues or 2 other students, all right? Lastly, there's a tip for finding articles. You can go to Scholar, Google Scholar. You can also, and once you're getting to Scholar, you can link to the Cal Baptist Library, and then that will give you access to any and all the articles that you need to find. Okay, all right, and so that's the first one, and then the second one, the second assignment that you have is the thesis style essay. Okay, so the thesis style essay, and this, you are to develop a thesis style essay that consists of a thesis paragraph, a minimum of 3 content sections, and a summary paragraph. Okay, remember the thesis paragraph should contain a strong thesis statement. So this is the declaration of what you're going to be talking about, right? And 3 supporting themes that will frame the essay. So, what you're going to talk about, and then how you're going to illustrate or explain the essay. All right. The essay must briefly frame a conflict scenario that could occur or that has occurred. This could be a real life scenario that you have experienced or you have been aware of, or it could be something made up. Okay. Remember to make it well developed but brief. Okay, 2 to 4 sentences, and remember that the conflict is not the topic of the paper, just the framework for you to be able to have a greater, broader discussion. Okay. And identify. Then you are to identify the ADRs to address the conflict. So explain that ADR in detail, and why it is the recommendation. Why is it the appropriate remedy for that conflict? Why is it the appropriate ADR for that conflict? Okay. You can also explain why the others are not appropriate or not as effective for that specific conflict. All right. And then provide a summary, and remember also to use APA format, minimum of 4 outside sources, 3 to 5 pages in length, and of course upload it to the assignment area in Word or PDF. Okay, so it's kind of an assignment heavy week, this week 6. We have these 2 pretty solid assignments. I hope you enjoy the week. I hope you enjoy the topic of the week, and of course, as always, I bid you a wonderful week, and God bless you all. Thank you very much.